Well, hello world. Welcome to the first annual Green Rights and Warrior Lawyers Virtual Academy. I'm Stephen Wood, the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia on the traditional, ancestral, and unceded territory of the Musqueam Nation in Vancouver in so-called Canada. This is the 9th and final session of the Academy. We're so excited to have reached this point. We're privileged for this final session to be joined from Aotearoa, New Zealand, by the Maori legal scholar Jacinta Ruru. As we get underway, I would like to invite everybody, and if you were at previous sessions, you will have heard this before, to introduce yourselves in the chat. And also, if you're comfortable, to turn your video on so that we can all see one another, because the idea of this event is to be interactive and relatively intimate rather than a talking head webinar sort of presentation. The session is being recorded, and the recording will be available on the website of the Academy where you went to initially register for this event, and it will also be on the YouTube channel of the Center for Law and the Environment. Jacinta's talk will be followed by commentary by my UBC colleague, Robert Clifford, and by audience Q&A. We invite you to pop questions or comments into the chat at any time. You don't have to wait until the Q&A period, although I don't guarantee we will answer questions until then. And when the Q&A starts, we will also give you the option to unmute yourselves and ask your question aloud, which again helps to emphasize the interactive and conversational character of this event. When we're finished the sort of formal part of the event, we're going to switch to a more informal, even more intimate format for a chat around the virtual kitchen table for audience members who are interested in staying to have a really relaxed, informal chat with Jacinta and Robert. Originally, we had planned, and you may have done this already, on having people register for a separate Zoom link where we would go for that conversation, but we're not doing that. Our groups are small enough, and also it just helps with the simplicity of things. We will just stay in this Zoom room. So those of you who want to join that after talk chat, just stick around after I sort of close the formal portion and stop the recording. Now it's my pleasure to introduce our commentator for this session, who will in turn introduce our featured warrior lawyer, and I hope you don't mind that moniker. Pardon me, Jacinta. So Robert Clifford is a professor here at Allard Law School. He's Kusanich and a member of the Sayote First Nation, his home community. He carries the name YELKATİ, which was passed to him by his late grandfather, Earl Claxton Sr. He recently completed his PhD, and big congratulations on that, exploring the ways Kusanich laws are generated by and reflect the values, philosophies, lands, and worldviews of the Kusanich people. He's actively involved in the academic and broader community. He has presented his work widely across academic and professional settings, speaking also at community events. His publications cover a range of aspects relating to Indigenous law and Indigenous legal theory, including legal pluralism, Indigenous language revitalization, and Indigenous spirituality. He has created and taught a semester-long intensive land and community-based field course on Kusanich law that's open to students at both the UBC and University of Victoria law schools, and also a seminar here at the UBC law faculty on Indigenous law and climate change. Thanks so much for agreeing to join us, Rob, and I'll hand it over to you to introduce Jacinta.
Hi, Stepan. I got briefly distracted. I was watching a family of otters just slide into the ocean off of the beach right in front of me here, which is always an amazing sight to see, and good timing on their behalf. So, Jacinta Ruru is a distinguished professor of law at the University of Otago. She researches Indigenous peoples' legal rights and responsibilities to care for, own, manage, and govern lands and waters. Tiriti o Waitangi and reconciliation, and state law recognition of Māori laws. Professor Ruru has numerous awards and recognitions, including being recognized as a fellow of the Royal Society of New Zealand. One thing that struck me when I was looking at Professor Ruru's many accomplishments and recognitions is the number of students she has worked with and the amazing projects that they've been undertaking. And I'm not just saying that because she recently agreed to be my external examiner, or was my external examiner for my PhD dissertation, but the list of students is amazing, and I think it speaks to how devoted she is to guiding and helping open doors for other scholars and being the supportive and encouraging voice that I know she is, and working toward meaningful change. And so it's no wonder that she's also the winner of the Prime Minister's Supreme Award for Excellence in Teaching. So we're very lucky to have her join us today and to share her knowledge and her work. And with that, I'll turn it over to you, Jacinta. So,
oh, thank you, Robert, and thank you, Stefan. Look, thank you so much for this enormous opportunity to spend some time with you this morning in Aotearoa, New Zealand. So I thank you and welcome this chance to share and dream for just futures. Actually, I'm going to share my screen. I do have a PowerPoint presentation. Oh, so that's coming. Everyone can see that. Cool. Okay, so again, just thank you, and thank you for that heartwarming welcome to be able to sit with you all today. It means an enormous amount, and I'm welcoming this chance to share and dream for just futures where we all, including Indigenous peoples and our ancestors and our descendants, can be clearly seen, known and heard, and where we all, in response, listen, care and act. So I want to open my talk this morning in accordance with who I am and in my Indigenous language. So ka tangi te titi, ka tangi te kaka, ka tangi hoki a hau, mai e te whae o ki te ao marama, te hei mauriora. So this is the birds are singing, and I wish to sing too. Nei aku mihi kia ranginui e tūnei, kia papatūnuku e tako tēnei, tēnā kōroa, tēnā kōroa. So acknowledging Ranginui, our Sky Father, and Papatūnuku, our Earth Mother. Nei aku mihi, ko tēnei te mihi ki ngā tini mati moi mai rā, acknowledging those who have passed before us. Ko tēnei te mihi ki ngā mana whenua, acknowledging all the Indigenous peoples of the lands that we're on. E waka eki noa tēnei, me poto te kōrero, pēnā e te tangata e tūnei, nā reira e aku rangatira, tēnā koutou, tēnā koutou. And so recognizing all of the leaders in our lives. So my call to action, if we're serious about really wanting to create a better, decolonized and reconciled society, accounting responsibly with the horrendous past and the continuing colonial wrongs, and if we're serious about utilizing all the best sciences and knowledges available to holistically address the existential threat upon us of climate change and the environmental crises that are at least present here in my beloved lands that span biodiversity loss and polluted, unwell waters. So then we must open our hearts, minds and hands to empowering Indigenous peoples to lead us forward, not just to be consulted with. So we need to shift back power and resources to Indigenous peoples. And I think this is one of our greatest hopes for survival of humanity on this planet today. So turning to the specifics of my call to action, I'm zeroing in on a topic that is dear to me. If anyone has read any of my work, I'm often talking about national parks, and I thought I'm going to land with national parks again today. And my talk will explain why, but I want to first preface some of the stories that I am going to talk about today with some concrete legislative detail. So I'm starting my talk with the legislation, and then we'll hopefully bring it alive. And so I'm looking around, and I'm sure many of you are from other countries than just Aotearoa, New Zealand and Canada. But here's at least 2 examples of how current legislation is defining legislation. And I'm not going to stay on the slide for long, and I do come back to it at the end of my talk. But essentially, hopefully you can see just in that quick glimpse of this wording that Indigenous peoples do not feature here. This is a very Western worldview and science of our national parks. And why national parks matter to me, particularly coming from Aotearoa, New Zealand, 1/3 of our country is locked up in publicly owned national parks. And to me, these are our ancestors that are being cared for in a way that is not recognising a Māori relationship with those lands. So that's just a brief insight into why this really matters to me. So that's the national parks legislation. And this is the kind of the background to the legislation. So the motivating rationale for why these lands are protected. In Canada, it's ecological integrity. In New Zealand, we use the term conservation, which is very much about preservation and protection, locking up the lands, maybe for some scenic tourism use. Even though in both countries, the legislation explicitly recognises that the rights of Indigenous peoples are relevant. And in the New Zealand context, we have had this recognition for more than 30 years now. So just bear with me, that's just a little bit of background into the legislation. And my call to action is to draft a new purpose section for national parks. So a simple call to action that I believe has the potential to unravel conservation law, environmental law, and in turn, the continuing colonial stranglehold on prioritising only Western science and management tools for caring for lands and waters. In order to strengthen the role of Indigenous peoples have with the public conservation lands and waters, we must have a conversation about relinquishing power in favour of, in my language, tino rangatiratanga, or Indigenous sovereignty and Indigenous self-determination. This can be a catalyst moment for positive transformational change, and it will be a catalyst moment for us as a nation in the world to properly address our multiple crises and lay the foundations for a better future for all humanity. So why do I care? It's well known that colonial state laws around the world have done an enormous amount to damage, to destroy and disrupt Indigenous peoples' intergenerational responsibilities of environmental care and use. And so in the short talk today, I'll map briefly some of the advances Aotearoa New Zealand has made towards a decolonised society where state property laws and conservation laws are beginning to empower rather than terminate Indigenous Māori relationships with lands. And so in this country, Aotearoa New Zealand, where there's this beautiful blue sky, there's a slight breeze in the winds, it's springtime here, the birds are all chirping, there's lots of lovely activity. In this country, some innovation is evident, and our legislation is starting to recognise our Māori intergenerational responsibilities to the land, starting to recognise our personified ancestors that lie in the hills and in the mountains and in the rivers as being real and tangible to us. And so that is a nod to the legal personality component that you may be aware of in the New Zealand context around the Whanganui River, and I will briefly talk about that. But turning to the detail of this particular talk, I want to first applaud and honour the intellectualism, bravery and resilience of my Māori ancestors and relations then and now. And I often ask myself these three questions that I thought might be useful to mention. So these are three questions that I'm really trying hard to work through. If we see, number one, if we see and hear as a nation in this country Māori environmental ancestors, and I'll talk in a moment about this. So for example, our law recognises Aoraki Mount Cook, our tallest mountain, as being the son of the Sky Father, our Waikato River, our longest river in the country, as being an ancestor, to Udaweda as being the heart of the great fish that Maui, one of our demigods, fished up. What do we do in response if our legislation now sees that? Number two, if our colonial dominated current constitutional orders are no longer fit for purpose, what orders do we dream for? And number three, how do we seek to make right the rules of our country to enable well-being into the future? And it is in this quest that I argue that the discipline of law matters. And right now lies one of our greatest opportunities for positive transformation of society and conservation law, if we're willing to go on this journey, to wish for and then make real the principles for our future. So let me share a little about you, and I'm sharing here. This is our understanding of Aotearoa New Zealand. These are our Māori federational boundaries, our tribal boundaries, our societal federation boundaries. My father's grew up in his tribal lands in the North Island, in Raukawa, next door to our humble family Te Apunga Paparamu Marae, bookended by his mother's peoples, my grandmother's peoples of Ngāti Ranginui and Ngāti Maniopoto. My Pākehā English mother grew up to the west of my dad in her beloved city, New Plymouth, where her grandparents, my grandparents, had travelled from England to make their home. And I grew up in the lands of Ngāitahu, so this is down in the South Island, which we, from a Māori point of view, we see the South Island as one way we see it as a boat. I can talk a little bit more about this, and we see the North Island as a big fish. And so it's interesting to see that. So we're down on the big boat. This is where I continue to live now, on this big boat. So it's not my tribal area, it's the lands of Ngāitahu. And we're at a big lake. Well, you can't see it on that map. There's a big lake, Wakatipu, and at the head of that lake is a very remote area named Glenorchy. So I grew up in the lands of Ngāitahu in the far south, at the head of Lake Wakatipu in the remote Glenorchy, at the foot of the majestic Mount Earnslaw, the braided waters of the Dart River, surrounded by lands protected in the renowned Fiordland and Mount Aspiring National Parks, managed by the Government Department of Conservation. So this is my childhood upbringing of being brought up amongst two of really famous New Zealand national parks. Something seemed terribly amiss and remiss to me. Wasn't I also living in the stolen lands of Ngāitahu, at the head of the sleeping giant? So Lake Wakatipu, from a Ngāitahu perspective, is a giant. And if you look at the map of the lake, you can see his head and his knees and his feet. And it's one of the few lakes in the world that has it's a freshwater lake, but has a rising tide level, and it's said to be his breathing up and down. So at the head of the sleeping giant, on the boat that Maui used to catch the big fish that the Europeans named the North Island, wasn't I living near to the trails of the most precious traded resource in the Māori economy, greenstone? I don't know if you can see very well, it's in Pounamu there, a place deep with centuries of Māori history, knowledge, entrepreneurship. But none of this was visually evident in the mostly overlaid English place names of my childhood home. And so this childhood unease led me on to dream for better, more respectful ways to acknowledge Māori histories, stories and interests, to remain stewards of lands and waters essential to cultural identity and survival. And I ended up in the study of law and this isn't, I love this collection of stamps. My 6-year-old daughter was watching me put this PowerPoint presentation together this morning, and she was coming over and she was looking at all these stories of who we are as Māori. You can see the separation between Rangi and Papa, the Sky Father and the Earth Mother. The one on the bottom in the middle, kind of the very yellow one, that's the Taniwha, or the giant in Lake Wakatipu. It's the whole story around that particular lake where I grew up. There's stories there about how the sun was slowed down, and how the North Island was fished up. That's the top one over on there. There's Maui, the demigod, fished from his boat, fishing up the North Island. So I ended up in the study of law. Law hasn't been kind to Indigenous peoples. It has silenced, stolen and criminalised much of what is dear to Indigenous peoples. The discipline of law took hold of me in the 1990s. It was a chance encounter. It was not obvious I would go to university. Few we knew had, certainly no one in my family. And I was really inspired, very really inspired in my rural school education. But that changed, and it changed when I was about 15. So I was still in the school system, just. My teachers had told me to leave. I was still there. And for the first time, as a 15-year-old, I read a short story by a Māori author. So up until this whole time in my education, never been given anything by a Māori author to read, even though I was a ferocious reader and I was always in the library reading. I'd never read anything by Māori. And so this was my big light bulb moment for me personally. This was what really kind of changed my kind of my life and my outlook, and things all of a sudden started to make sense to me. So I read for the first time short stories by a Māori author about racism in our country. And so Whittier Maeda is an amazing Māori author, as is Patricia Grace. It was the two of them who really changed my life in high school, secondary school. One of these stories, The Yellow Brick Road, was the change moment for me. Here was a story about a Māori family on a road trip. And remember, I grew up down in the South Island, quite a long way away from where my mum and dad grew up. So we would go on these big road trips, and mum and dad, we had this very embarrassing car. It was this big yellow panel van. It's highly embarrassing. To me anyway, and because it wasn't normal what other kids had. They had no back seats. They had this mum and dad to sit at the front, and then there was just mattresses in the back, and that's where the three kids of us lie in there. And you just, New Zealand law, you cannot drive your kids around without seatbelts on and all that, certainly now, but that's the way we would drive around in this big yellow panel van from the South Island all the way up to the North Island on these big road trips. And so I think that's part of what helped bring this alive. This particular story here, and you can see just even in a glimpse, it's written in a way that's not, well, all the other stories, the English writers and so on that have been reading hadn't been writing like this, hadn't been writing with a strong Māori voice. And it's a story about this family who are traveling for the first time from a rural area into Wellington, into one of our cities, and the car breaks down and no one stops to help the family. And so it's this child's eyes into racism in New Zealand and the evidence of that. So I knew once I'd read this story, I wanted to learn more. And I thought then my career would be in documentary making to better understand colonial injustice in our society. But once I started the study of law, I was hooked. I didn't come into law until my third year of university. I mean, I got myself to university, my motivating reason, my motivating choice, because remember, no one around me had been to university, didn't really know what I was doing. And my choice of subjects was simply to choose subjects that I had not had a chance to study at high school. That was the only kind of rationale. And I did a lot of politics and Māori studies, sociology. And so in my third year, I picked up law. Oh, so in New Zealand, sorry, law is an undergraduate degree. It's not a postgraduate degree. So you can enter into law from your first year at university. I liked how I could build an argument to support a cause, to be heard in a forum that had to seriously consider it. the courts, but I struggled with much of the curriculum. It was perplexing to sit in a lecture theatres learning about legal positivism, primary rules and secondary rules, clear cases and hard cases, all containing underlying messages that law is objective and just. I learnt, for example, this is our legal system, although this wasn't my legal system back then when I was studying 20 years, 30 years ago. This is our legal system today, and it's a slide I use in my classes to try to explain the roles of, well, now the king. Earlier on this year, it was all woman leadership. It's had a change, obviously. And the second and first, we have a Māori woman, first Māori woman as our Governor General, and then we have our Prime Minister, and then our Chief Justice of the Supreme Court. And so just our balance between our Parliament and the courts. This slide speaks to or how I said is our branches of government, our Parliament, our executive and the courts. And so the role in law as we read the words of Parliament enshrined in legislation and the words of judges enshrined in court decisions, and we're told that their words are neutrally applied and interpreted neutrally by the courts. But I could not reconcile this unbiased standard of law with the stories my father's family told. These stories are about dispossession, deliberate dispossession from ancestral land from the 1860s onwards through insidious racist assimilationist legislation and local government rules. And I knew our experiences were not unique. All Māori families tell of similar accounts. And so these experiences in my tertiary education and in all of my formal education was mostly invisible. So the stories of my family was invisible. Studying law gave me an insight into how the law could be used to achieve colonial goals, and it did not convince me that law operates on an unbiased, neutral terrain. And so I came to regard the subject of law as both shocking and fascinating. So hundreds of years ago, the Europeans dreamed up their desire to expand their empires across salt waters. They developed a new legal doctrine, the Doctrine of Discovery. It holds that European countries can gain sovereignty of another people's lands on the basis of first discovery, even if other people lived there. And I think this is one of the greatest examples of the magic of law. The Europeans made up the law to suit their desire to expand their control of the world order. It happens then, it continues to happen. Colonial rules have been established to empower their colonialists. But if law is this powerful, law can do anything. And what now do we want it to do? And that's where I find the real hope going forward. By knowing that law is biased, we have agency to make real our dreams today in both a practical and constitutional manner. So if law is this powerful and it was able to do that, what it did to Indigenous peoples, it can do anything. What now do we want it to do? And this is what excites me, with our government now creating new law and recognition of a harsh history of breaching in this country our contract between the Indigenous peoples Māori and the British Crown in 1840, our Treaty of Waitangi. In the more recent years, for about 20 years now, of modern reconciling law, at the tail end of historical apologies, we have national laws that recognise Indigenous ancestors as legal persons. We have a number of statutes, and I'm just going to talk about some of this legislation very briefly, and also some of the stories of these lands. So this is Auraki. He's a male mountain. He's our tallest mountain in Aotearoa, New Zealand. He lies here in the South Island. To Ngāi people, he and his brothers were with Ranginui up in the sky, and they wanted to come down and find Papatonuku, their earth mother. And so they left their sky father and they travelled down on a waka, on a boat, and they couldn't find Papatonuku in all the waters. They couldn't find her. And so they kind of gave up, and they said a karakia, a prayer, to take them back up to their sky father. But Auraki here is the oldest brother. There was said that karakia incorrectly, I'm just really summarising this, sorry. He said this to any Ngāitahu who may even watch this in the future. So said this karakia, this prayer, incorrectly, forcing the boat, the waka that the brothers were on, to hit a hidden reef. And so the 4 brothers scramble to the top of their waka, and their waka, their boat, turns into the South Island, what we now know as the South Island, and these brothers stand there as the tallest mountains. And so for Ngāitahu, to understand the laws and the values of who the Ngāitahu people are directly relates into this ancestral mountain. So just for example, as an example of one of our laws, it's inappropriate to touch someone's head, and there's lots of rules around the head. So Robert, I can see your hat that you've got on. So for us, okay to wear a hat, but you wouldn't then put that hat on the table or near food. There's a whole lot of, we've got a lot of cultural laws around, particularly around the head and what touches the head, and then whatever touches the head, where it's then placed. Those rules apply to this mountain as well. So it's inappropriate to go to the top of this mountain to touch the head of Auraki. And there's lots of reasons and so on, replicating the responsibilities we have to one another. So that's Auraki. Here's Tongariro, this is Taranaki. This is where our second national park in New Zealand was created. Taranaki is another male mountain. How much time have I got? So he's a male mountain. He used to lie he's in the North Island. He's all out on his own now. If you know anything about the geography of the North Island of New Zealand, he's a male mountain that sits all on his own. He's got flat, now it's all farmland all around him. It's quite unusual seeing a really big mountain on its own. And amongst the really flat, big areas of flat expanse. But he used to be in the middle of the North Island, really close to Tongariro, another male mountain. Tongariro is where our first national park was encased over. So Tongariro and Taranaki used to live together, and they had this big battle over a female mountain that Tongariro was married to. So Tongariro had his relationship with a female mountain. Taranaki was quite keen on her. They have this big battle, and there's lots of other mountains that are part of this big battle scene. And one way that the story is told is that Taranaki loses this battle and is banished off to the side. And so his movement across from the middle of the North Island all the way across to the west of the North Island helps form the Whanganui River. And the Whanganui River is our 3rd longest river that goes from the mountains all the way down to the sea, that has become kind of world famous now, as is now recognised as using this tool of legal personality. So for Māori and our Māori laws, everything matters. At the centre of our Māori legal system is what we call whakapapa or whanaungatanga relationships. The relationships not just meaning our relationships to mum, dad and our 3 children or our grandparents. From a central component of the Māori legal system is our responsibility and our relationships to our ancestral mountains, our ancestral waters, our relationships to the birds, to everything around us is centrally important to understanding who we are and how we live our lives. And now, for example, the Ngāitahu Claims Settlement Act recognises that Auraki here is an ancestral mountain from 1998, Te Urewera Act, first act, very incredible piece of legislation that removes a whole national park from the conservation order. This is unheard of. This goes against the whole, from a Western point of view, this goes against the whole idea of that when you create a national park, that it's locked up in perpetuity for all time. Here you have the removal of a national park from national park legislation and being returned to the Indigenous peoples. And again, legal personality is used as the tool here. We'll talk a little bit more about that. So for Tūhoe, it's this beautiful big lake area. It's the heart of that great fish. Remember, I've been saying about how Maui fished up the North Island, and that fish is the North Island, and the heart of that fish here is Te Urewera. And that's now recognised in law, like this wording that Te Urewera is the heart of the great fish, that now sits in our legislation as recognition. And here's the Whanganui River recognition that this third longest river is an ancestor, and legal personality tool has now been used to recognise this place as having the rights, responsibilities and duties of a legal person. So does Te Urewera. And Taranaki, that big mountain I just talked about before, the male mountain, he also is likely to have a legal personality tool kind of over him in terms of recognising the Crown's not going to own him. The Crown's actually not going to permit Māori to own them. So it's a middle ground, and that he'll just own himself. And so that's the tool of legal personality. So legal personality is a vibrant and a real way to displace Crown assumptions of ownership throughout the world. And governments have the opportunity to lean in and learn from Indigenous peoples to recreate laws and policies of care for lands and waters that make sense to Indigenous peoples, and to address the recent centuries of legal and societal racism and bias. Oops, sorry, I'm pushing the wrong card. So recognising nature as legal persons enables many things for us as a country. So legal personality transforms our nation's legal system by placing at the forefront of our country a Māori way of understanding all that is around us. And in the words of our then Minister of Māori Affairs, when legal personality was first introduced into New Zealand with that Te Urewera Act in 2014, our Minister of Māori Affairs then said, legal personality offers us a profound alternative to the human presumption of sovereignty over the natural world. I think that's really powerful wording. It's remarkable that our country has recognised a forest, a river, and soon to be a mountain as illegal persons. This is something I thought would never happen, despite arguing it was possible in all of my writing. And so the possibility for change does exist, but only if we can be truly brave. And I think it's now time to be next level courageous. We need to take another big step forward. So turning to my call to action in this talk today and dreaming for new legislation, let's look at New Zealand. So the umbrella legislation to the National Parks Act is the Conservation Act. So the Conservation Act sits over about more than 20 other statutes, and one of them is the National Parks Act. So the Conservation Act establishes our Department of Conservation. In Canada, that's similar to your Parks Canada. So the Conservation Act has had since 1987 this direction to give effect to the principles of the Treaty of Waitangi. Our Treaty of Waitangi is recorded in both the Māori and English language, and in the Māori language, it recognises Māori sovereignty over our lands, forests and fisheries, and if we wish to sell them, we'll sell them to the British Crown. By reading just section 4, you would think nearly 35 years on that we would have a system of conservation management in this country that is at least bicultural and power sharing, bicultural in science, Western science and Māori science application, and bilingual in expression. We don't. This point has been made forcefully by others for a long time, including the Waitangi Tribunal, which is a permanent commission of inquiry in New Zealand. 10 years ago, when the tribunal stressed that partnership is the intellectual framework for understanding the Treaty of Waitangi today, and quoting from the tribunal, the Department of Conservation must be looking for partnership opportunities in everything that it does. Opportunities to share power with Māori should be a core performance indicator for the department, rather than the exceptional outcome driven by wider pressures of treaty settlements. So in New Zealand, yes, we do have some amazing legislation, like the Whanganui River, like Te Urewera, but they all come from negotiated Treaty of Waitangi settlements. They are not driven by our Department of Conservation and seeking a partnership relationship with Māori. Our current conservation law has been born at a time where policymakers and government members were heavily influenced by the Western conservation ideals of the 19th and early 20th century. This law has at its heart an English colonial idea of conservation. There is a significant mismatch between a Māori way and responsibility of caring for lands, which is about being part of those lands, living in those lands, caring for and having responsibility for those lands and waters in a two-way relationship, just as you would with your children and your grandparents and so on. Here you can see the definition of conservation. And then mapped out of the 25 statutes that the Department of Conservation in New Zealand administers. So these are all existing legislation. So we still have some existing legislation in New Zealand that was passed in the 1800s that's still operative today. You know, some from the 1920s. The 1950s example would be the National Parks Act, and our Wildlife Act is from the 1950s as well. There's quite a lot in the 1970s. So this is law that was enacted at these dates that still continues to be the relevant law today. What I'm trying to emphasize here is of the 25 statutes that the Department of Conservation administers today, only 4 have been enacted after the first modern Treaty of Waitangi Settlement Statute in 1995. And so all the other statutes that are sitting in New Zealand in a conservation realm have been framed from an entirely other area that has been influenced by Western colonial ideas of conservation. So most of that law is silent on anything Māori, and I would go further in saying it's hostile to Māori leadership, Māori sciences, including acts like the Wildlife Act and the National Parks Act. So just watching the time. So of course there are some great initiatives going on within the Department of Conservation in New Zealand, but still a coherent and coordinated overhaul of the whole discordant framework of conservation legislation is required to catch up to the innovation of Māori ideas for caring for lands and waters. And we only need to look at what happens when Māori do have the pen. And so te kawa o te urewera. Te kawa is the rules, the laws of te urewera. So because te urewera was once that national park, 2014, it's been returned to Māori, to Tūhoe. Tūhoe have now held the pen in writing it's not really a management plan that you and I would think of as a management plan for a national park. It's a commitment of care to this place. So it reads, and I think it's some of the most amazing, beautiful writing in the English language. It's also written in the Māori language, but you can read it in the English language. I encourage, if you haven't had a chance to have a look at it, definitely go online and read Te Kawa o Te Urewera. It reads like no other national park management plan I've ever read. It deliberately sets out to disrupt the norm. So that's quoting, it strives to manage people for the benefit of the land rather than manage the land for the benefit of people. I mean, isn't that just such a obvious kind of component? But it was like, wow, of course we should be, you know, managing people for the benefit of the land rather than managing the land for the benefit of people. Just turning things upside down. It's a remarkable document that embraces a process of quoting. So Tūhoe are absolutely saying we are here unlearning, rediscovering and relearning to seize the truth expressed by our beliefs. The orientation of the plan is stated as, again, quoting, deliberatively, we are resetting our human relationship and behaviour towards nature. Our disconnection, because of colonialism, our disconnection from Te Urewera has changed our humanness. We wish for its return. And so as embraced in all decisiveness, we are returning to our place in nature as her child. And this plan knows that the answers to biodiversity well-being lie intimately within the lands themselves if we listen carefully. And so I'm just going to quote a part of the plan. Nature speaks all the time and is understood only by the sincere observer and heedful mind and heart. Humanity has much to gain from reigniting a responsibility to Te Urewera, for within these customs and behaviours lies the answers to our resilience to meet a forever changing climate. Through committing to Te Urewera values, we are innovating our instincts and adjusting our behaviour to ensure a prosperous future that is secure. And so I think that is a really powerful example. If we listen and hear what Indigenous peoples are saying, and we have a real opportunity for us going forward. And the component of that is having a new relational core. And some of our judges in the court system are starting to catch up to these ideas that are inherent within the Māori legal system. And this is a relatively recent case, came out last year from our High Court. And it has a whole new way of regarding property law that I thought was quite interesting to share. It's just one of examples of some really interesting case law coming out of New Zealand's senior courts. So Dominion, Imperium, I don't know how many online law graduates and so on, Dominion and Imperium. Dominion is property, Imperium is sovereignty. So these go to the heart of any country, who has control of as sovereignty over the lands and who has control over the property. Dominion and Imperium had no counterpart in tikanga Māori, so that's Māori law. And the Māori view of creation, the central figures, Papatōnuku again, our Earth Mother, Ranginui, our Sky Father, with the earth being created when these two were thrust apart by their children. They are regarded in Māori law as ancestors, and one does not own one's ancestors. Ancestors are the source of whakapapa. So going back to that idea of genealogical connection, and whakapapa, or that genealogical connection, is at the heart of Māori law and dictates Māori societal norms and relationships. And Māori law, rather than there being an emphasis on exclusive individual or collective title to any part of the land, the focus was on the use of and relationship with resources of the land. And so there's some really good platforms and components in Aotearoa in New Zealand to now connect with a Māori way. We've got some great legislation. We've got some, I'm thinking there about Te Urewera and the Whanganui River legislation, not the conservation law, that needs to catch up. And we've got some good court decisions. And I'm not going to stay on this, I know I'm out of time now, but really just to, there's a lot of thinking going on amongst Māori and amongst New Zealanders, and particularly around our commitments and law now, or internationally, to the United Nations Declaration on the Rights of Indigenous Peoples. And if we're trying to bring together and make so for New Zealand in 2040, will mark 200 years since the signing of Tiriti or Waitangi. So a lot of us are really working towards what is our country going to look like in 2040. So for example, one of the aspirations is that, so we're a country of 5 million people, New Zealand, by 2040, 1 million will be speaking the Māori language again as a first language. So there's some big commitments that we're working towards for 2040. This is a document that was appointed by the Minister of Māori Affairs, so a government appointed group, to come up with a draft plan to make New Zealand compliant. We're only given like 10 weeks. We weren't given very many resources. It was an incredibly opportunity, but it has become completely politicized. But it works in a framework of thinking about, okay, here is a Māori sovereignty sphere, and sorry, this is in Te Reo, and the Kāwanatanga sphere is the Crown government. So both have a right, we accept both have a right to govern in New Zealand, and that there should be a joint body as well. At the moment, back in 2019, when we mapped this, that Kāwanatanga sphere, the Crown takes over the governorship of pretty much everything in our country, and very little opportunity for Māori to exercise self-determination, sovereignty. But we need to shift this, and by 2040, a massive shift is what we're calling for, is the shrinking of that Kāwanatanga government sphere, the increasing of that tino rangatiratanga Māori sovereignty sphere, and some more joint sphere. So being much more deliberate now around, okay, what is this law and policy trying to achieve? Where is it trying to fall? And so amongst that background, and my call to action that I'm really keen to advance is looking at one of these colonially constructed statutes, which is the National Parks Act in New Zealand. And it's a 1980 statute recognising that this needs to, that this, you know, this whole concept of how we define national parks needs to change. And how do we do that? And how do we dream for and write up a new way of thinking about national parks that recognises these places as important to Māori or to Indigenous peoples, not just in the past, but going on into the future, and that a Māori relationship with these places that are locked up in national parks is one of our greatest ways to think about how as humanity we're going to come together and work through the huge crises that our lands and waters are facing. So thank you for the opportunity to sit here and be with you all today. Thank you.
Great, Aishka. Thank you very much, Jacinta. So I have a few minutes to jump in and offer a commentary. I mean, there's already so much material that we've covered there. It's hard to know where to begin, really. But I suppose just picking up on the calls to action, for instance. I mean, if we think about what's happening here in Kusainich, so for those who joined late, I'm Kusainich, which is on the south of Vancouver Island in British Columbia, Canada. We're working with lots of similar things. So your work has been influential over this way as well. Working with Parks Canada and thinking about how some of the national parks might be returned to percentage ownership or co-management, and then also with the marine areas, thinking about what National Marine Conservation Area reserves might look like. So management over water or ocean territory, being an ocean people. Water gets complicated because it's a whole different system operating there in terms of property and use and jurisdictional lines and whatnot. But also I was using some of your work in this thinking about legal personality to influence or recommend how that might look with some opportunities we've had here in Kusainich as well. We've had some small pieces of land returned to us, small island just out there, Sisquanam. And often the land comes back with particular conditions attached to it. We had Jack over here on my screen anyways, working with, he was in my field school that was mentioned by Stephan, working on some of these things in different areas. But how do we think about having land back, but the conditions that get attached to it is often complicated? And you spoke of the option of having a legal personality granted as sort of a middle ground between those things. So something that we've been thinking about and exploring over here as well, and have drawn on your work a lot in that regard. One thing that I really enjoyed about your talk, and I'll echo the same, Tikawa o Uruea is such a fantastic document. I've read many co-management examples again myself, and it's amazing. I agree, it's the best that I've seen as well. So but I was thinking through a number of things. One thing that came up is you mentioned this listening. If you listen, it's in there, but also different statements you read about listening to the more than human world and our ancestors, however we might describe them, or same with the islands here, we speak of ancestors and relatives. That process of listening, and as far as I understand, with the different legal personalities that have been created, there's also a board structure that gets put into place where representatives from the iwi, the tribe, if you want to use that word, and government and so forth will be the face of Te Urewera, for instance, and speak on behalf of. So one, I guess I'm just wondering, I know that there's in the Act, there's stipulations about who gets to be in those positions, and that has some connection with this ability to connect to those teachings and listening. But I wonder, I just find myself wondering and would be interested in hearing of, so I don't know, I'm just turning this somehow organically into the conversation side of things here and skipping out on my commentary duty, I guess. But I was really interested in what you think about the benefits and limitations of those types of boards, because it's also very hard for many people to think of or to understand what it might mean for an island or a mountain or a river to be able to speak and to be able to listen, and then therefore insert that river's own agency and being into a political legal discourse. So we have people, individuals on this board doing that on behalf of that. But I'm also wondering, so obviously there's a benefit there, but I'm also wondering what a different model might look like if we wanted to, if that were appropriate, or if we strove for pushing for something further. Like I think you used the next level brave, at least that's what I wrote down, but like, what would it look like if that were just envisioned absent any other particular constraints? How might we think about maybe shifting subjectivities or whatever it is, creating that change where individuals, societies, communities feel that more and enact that? And people have asked me this question, so maybe I'm just kind of cheating and asking you, but it's a hard one to answer, and I'd be interested in hearing your thoughts if you wish to share them.
Thank you, Robert. I think that next level brave is about having a conversation of being able to return, the Crown government being able to return large tracts of land without conditions on it, that we can as a country be really confident to place something that is special to all of us as New Zealanders. So Te Urewera is recognised as it's been a national park for a long time. A lot of people have connections with that place. So a place that is special to all peoples. Can we have confidence as a country to enable true Indigenous leadership and responsibility for that place? Does the Crown still have to have it within, work within the confines of its own legislative order? And I think that is the opportunity that we have to be that next level brave. In saying that, though, I do believe the example in Te Urewera is an incredible moment. And so there's a transition that was enabled in the legislation that initially, I think it was a 50-50 board between Crown appointed persons and Tūhoe. And after the first 3 years, that's now 75%, I think, Tūhoe managed now. So it still does have some Crown involvement there, and it still does need to link into New Zealand law and so on. So it's still, when you read the actual Act, it still replicates some of the national park legislation and so on. So it still has all that. But what it does have, it has enough triggers in there or catalysts in there to create some real change. It has Māori majority, by far majority leadership. It has, the legislation recognises the place of Māori laws. So Māori laws are relevant for the place. And actually what happens on the ground, and this is what, legislation is just one part of it. What actually happens on the ground between people and their relationships and that power and control and often money. So where's the budgets? Is the Crown government given Tūhoe, the budget to be able to really care for these lands in the way that they wish to? So I think all of those are things that need to be looked at really carefully, and I think, in terms of coming through into a sophisticated modern world, we should have lots of different options and models operating, some that are entirely Indigenous owned for the benefit of the whole country, you know, for everyone, some that are Indigenous owned just for Indigenous peoples. You know, under our own Māori laws, we've got this notion of a rāhui, or something that would restrict entry to only certain people. Already under the conservation law, we have areas that are restricted just to New Zealand scientists. So you could have to have a permit to be able to enter these places for science endeavour. You know, could we envisage also having places in New Zealand that are under Māori laws that only permit Māori scientists, Mātauranga experts, to be able to access for certain periods of time? I think, you know, we've got to be able to have conversations across the whole board and have on the table lots and lots of different ideas. And so I'm really excited to think through what those ideas are and what those different models might be. And I hope that we'll have many. Just when you're talking about listening, Robert, I thought I'd just think it made me, first of all, it made me really think about our Māori language, and that we have, if we listen really carefully to Māori and the Māori language, we have reminders of our responsibilities to the environment in all of the core identity markers we have in our language. So, for example, whānau is a word we use all the time. Actually, we saw it on the screen here. I used whanaungatanga, which is to make the family. So whānau is family. So you can think about it in a whānau as mum, dad, and the three children. From a Māori perspective, we would think of whānau as the, you know, as also our relationships to the mountains, the lakes and rivers. But also whānau means placenta. And so that's that reminder that when a child is born, the placenta of that child must go into the ground, into the earth with Papa Tūnuku, with the earth mother. And so there's just all these little reminders to be hapu. So hapu is the way that we describe kind of, I know the English horrible word is sub-tribe, so, but hapu is, you know, a group, a bigger group of that whānau, so a bigger you know, bigger grouping of Māori, hapu. But hapu also means to be pregnant. So I think I just sort of leave that and sort of thinking about our Māori language and these reminders. Iwi is our tribal name, but also means bone. You know, there's all these reminders in our language about our relationships. Kia ora.
Lovely. I'm going to open things up to questions from everybody in a moment, but I think that now is a good time actually to close the formal part of the session with a huge thank you to Jacinta and to Rob for your thoughtful contributions, and a little plug or reminder that even though this is the last session of this year's first annual Green Rights and Warrior Lawyers Virtual Academy, the event as a whole is not finished yet, because we have the second component of this event, which we invented the word Inspirathon. And the Inspirathon is an activity open to university students from all around the world to engage collaboratively in researching and brainstorming ideas to advance a campaign that is being spearheaded by one of the other featured warrior lawyers in the academy, the Philippine environmental lawyer, Tony Opoza. And that is to transform unsustainably exploited exclusive economic zones of the ocean to sustainably stewarded enlightened ecosystem zones. So that's how Tony puts it, and we're still open for teams to register for that, undergraduate or postgraduate university students, and it carries on until November 30th. So you can find, well, actually Emma has just popped a link in the chat. You can find more information about that, and please do share that idea with people you know who are university students. And at that, I will ask Emma to stop the recording.